I do think the court in Rumsfeld was dealing with the sort of compulsion that is significantly different from the compulsion here. In what other case have we upheld compelling speech? In other words, not simply just restricting speech, but actually compelling an individual to engage in speech contrary to her beliefs?
So I think, Mr. Chief Justice, Rumsfeld really is one of those cases, and I want to emphasize that the law schools there really did have a very credible claim. I think that they deeply opposed the military's policies. And
well, they opposed the military's policies, but all they really had to do was give them an empty room.
Mr. Chief Justice, that's not correct. At pages 60 to 62, the court acknowledges that there were things that the law schools were required to do, like sending emails, coordinating meetings, including announcements in their newsletters, that were clearly speech. The court below had held that
advising people that the military recruiters were available in a particular room, right?
And including their announcements, distributing the announcements on behalf of the military, including the military's announcements in the law school's own newsletter. The court below held, and the law school
of the fact that they would be recruiting on campus pursuant to the Solomon Amendment. Do you think that's the same as the speech that's compelled here, which is directly opposite to the beliefs that the Ms. Smith is seeking to convey?
So I think it depends very much about what type of speech we're talking about here. I don't know that it is different in a constitutional sense from the sort of speech that was described in what Justice Kagan, I think, called the basic website, where we're talking about a website that presents in an attractive way the details of the couple's wedding. I think it might be a very different case if she were compelled, if Colorado ever applied its law to compel her to create messages or express religious views about marriage or to do some of the opinion-based statements that Justice Kagan described. But I think that case might well come out differently.